Before I start sharing with you what I intended to today, I must say that I find this expression justice unplugged a bit of a misnomer, and I'll tell you why. Justice was never plugged. It has never been plugged. Justice is like water. It flows into any opening, fills any vacuum, flows into cracks, flows into crevices. It is ever flowing wherever society needs it. What has been plugged was society. It is society which was plugged. And that plugging of society has opened over the years. It has slowly become unplugged with changes in social norms, social customs, social beliefs, changing in the economic order, the areas of professions, the area of businesses, and above all, even in fields like medicine and other fields like that. You have seen significant changes. You have seen changes where we have come into internationalism, and you have had such far-ranging changes that all that has happened is justice has had to move along with these changes, deal with all these changes through its handmaiden. And its handmaiden is law. And all of us are nothing but the messengers, the carriers of that handmaiden. So what we really do is keep in pace with society. Let me go back in time. It was almost 50 years ago when I joined the Law College, Madras. It was very amusing because in those days, at least at the time I joined Law College, it was really the last refuge. If you couldn't get into the administrative service, if you couldn't get a job, you didn't go into law. There were only three reasons to go into law. One, you had a family of lawyers, therefore you had an abiding interest. Two, you were in politics and felt law would help you in your political field. Or three, you had no other alternative. You had no employment. You could do nothing else. In fact, I must tell you on a lighter vein, when I went for my interview for the Law College admission, I had done very well in my graduation. In those days, we didn't have a 5-year course. You were a graduate before you joined law. And I had done very well in my graduation. And a member of the interview committee said, but tell me, why are you applying for law? So I said, because I want to do law. He said, but you've done so well in your BA. Didn't you see today there's an advertisement from so-and-so bank for clerks who can become officers? With your marks, you can definitely get that job. Why are you coming for law? Then I had to convince him that I actually wanted to do law, and would he mind, despite my good marks, giving me admission in law school. That is the way it was. When we went to law class, our only interest was attendance, nothing else. I'm being very frank with you. We were given lectures where the teachers would take out a chapter and read it to us, and we would all sit there and listen to this reading of this chapter. We had teachers who were disinterested, students who were completely disinterested, and that is the law we grew up in. We started learning law when we became lawyers. In fact, I remember I had a problem drafting my first legal notice when I was a junior in a law firm. I didn't know exactly how to go about drafting a notice asking somebody to return the money he had borrowed and for which he had given a promissory note. That was where we started, because that is where law was placed in those days, as being nothing but a job which you did, by which you did cases which were quite pedantic, because law had not started growing. And why? Because society had not started growing. Times have changed. We had no such thing as competition laws. We did not know what competition law meant because it didn't exist. We knew that unfair trade was actually preventing somebody from doing his business, either by getting some people to beat him up and to close down the shop, or to put up some other building before it. That was unfair trade. There was no such thing as competition law. There was no such thing as securities law. IP law did not develop. The IT law, the technology law is something which we didn't even dream about. So for us in our days, law was completely a different issue where we had nothing but solving lis inter se people, or we had criminal matters where the state versus a client who has committed a crime which falls under the IPC. But over the years, law has got involved in so many spheres of human life, so many spheres, that today it has become almost impossible for any lawyer to keep up with the different spheres where law has now taken a place. So we've got this age of super specialization. I mean, I can only go back to years ago when I heard the story about this chap who came back to his village and told his village doctor that he'd now become a doctor. So he said, all right, so what are you doing? So you're a doctor. He said, no, I've become an ENT specialist. He said, what's ENT? He said, ear, nose and throat. He said, oh, I see, very good. He said, but then I felt that's all too much, so I specialized in the nose. So the man said, oh, I see. And which nostril are you specializing in? So that is where we are coming more and more, which is why you students today are getting more and more dependent on Westlaw, on your various technological assistance for studying your cases. I don't blame you for it, but can I give you some advice? Do not sacrifice original thinking. Original thinking is a must. I always appreciate an associate in my chambers who comes out with an original thought which may have a flaw, rather than repeating for me what has already been stated in some judgment. I'll give you 2 pointers of myself. I'll just share with you 2 things which actually I'm not letting out a professional secret. Before I was a counsel, designated a senior advocate, I used to do a lot of original side work and writ work. And I used to do a lot of drafting. Do you know how I used to draft? I used to first draft the relief, even without reading the facts of the case. I would ask my client, what do you want? Once I knew what he wanted, I would draft his relief. After drafting for the relief, I would next draft the cause of action, which is required to establish that relief. Then I would set out the law which was required to make out that cause of action. After that, I would go through the facts of the case and then see what are the facts which support my cause of action and the relief, and highlight those. And then I would take the facts which were not in my favor and deal with those. Because one thing one never did and one never should do is suppress a fact. So that is the way I used to draft. And it's very interesting to know that that kind of drafting is something I did all my life, and even today in the Supreme Court when I'm asked to settle a synopsis, I tend to think of it the same way. When I'm asked to settle an SLP, I tend to think of it the same way. The other thing which I always do and continue doing till today is that I'm briefed in a case, I first understand what the facts of the case are. Then, when I'm told there's this judgment or that judgment, X, Y, Z, I say, please put it all away. I don't even want to see them. Don't even tell me what the judgments say. I'm not interested. I say, show me the act. It could be an act which I have read the section 100 times. I may be able to recite the section to you, but I read the section again. I read the relevant sections again, and then look at the facts of my case, query that section, and then come to my conclusion as to what the argument should be. I say, all right, now you can show me the judgments, either for or against. Then when I read those judgments, what do? I first read the most important paragraph of the judgment, which is not the ratio decidendi. The most important paragraph of the judgment is usually paragraphs 2 and 3, which are the facts of the case. Then come to the decision. And you will understand then that a decision which was seemingly against you may actually be in your favor when you see the facts there and you see the facts in your case. Now, instead, if somebody was to say, sir, I have just got these 6 judgments on this point, this is the case coming up tomorrow, here are these judgments, this is the ratio XYZ, I have lost any form of original thinking for the case. And according to me, this is the most single important thing for all of you to continue in life, especially in lines of what I'm going to talk to you about, the changes of law. The second very important thing is that why is our profession known as the learned profession? I mean, we call ourselves a noble profession. I trust many of us believe we are noble, but why are we called the learned profession? Why do we say, my learned brother, my learned friend? Why? Because it was and should continue to be a learned profession. Before we joined law, we went through a graduation. Why? Because we had to be taught, understand, and have a degree of learning before we approached law. Today, I appreciate again that I know what all of you are combating. You're combating so many different specialized fields of law. It's gone far away from general law. So you will find that perhaps you have no more time than to read your law books. But please understand that reading is vital. Whether it's literature, philosophy, general affairs, topical affairs, business affairs, no lawyer can be a complete lawyer if they are not learned in all subjects. Because if you're learned in all these subjects, and if you have actually understand all nuances of social subjects, of subjects you find in the world, even little bit, I think Dr. Selvan just spoke about my case on medical malpractice. Do you know, by the time I finished that case, and I want to share a story with you, I had sat with the doctors to understand what is pulmonary edema. And I was told that, this doctor explained it to me so beautifully. And she said, you can hear it. Because this is when she gave evidence. And the doctor said, but doctor, when cross-examination, how would you know you had pulmonary edema? And she said, because you can hear it. And then I asked her afterwards, you said that so beautifully and the judge was so impressed, but how do you hear it? And then she explained to me. And do you know what happened to me 5 years later? My father wasn't well. And suddenly, my mother called me and said, look, something's with him. And my mother was a doctor. Had been a doctor, wasn't practicing. And said, I don't know what's wrong with him. He's lying almost in a coma. And suddenly I heard the rasping. And I said, Amma, he's got pulmonary edema. Let's rush him to the hospital. We rushed him to the hospital and he had pulmonary edema. Now, this has nothing to do with law, but I'm just sharing with you how knowledge, learning of any kind will always assist us and never hurt us. So these are aspects I want you to tell you that despite you're going to have so many specialized sessions on so many specialized issues today, you're going to be doing that. I don't want to talk about these specialized issues. We have so many sessions with so many experts who are going to talk to you about it. I want to talk about these general facets. And the main general facet I want to talk to you about is to understand that society has changed over the years. Law is the handmaiden of justice. Justice deals with society, social norms, social customs, religious tenets, deals with business realities, commercial realities, criminality, deals with all these aspects. Which is why the courts in India have also tried to keep pace with this. When I joined the bar, we didn't have so many different statutes. Money Laundering Act was not heard about. All these other acts were not even contemplated. What did the courts do in those days? Let's think of some judgments. Don't forget, in those days, when there were no hard and fast rules, the great Kesavananda Bharati case, where the court saw the injustice of throwing away valuable rights and duties under the Constitution, and then decided, how do we protect it? And through a series of original thoughts made explicit what was implicit all along, and came out with the basic structured doctrine to save the basic structure of morality, humanity, constitutional morality of what our forefathers had wished. Then you take a case like the Bangalore Water Supply Company, recognized labor rights, recognized the importance of these aspects because these became something which statutes are not dealing with. We went on to, then we have, of course, the famous case of Mr. Rangarajan, who was then the publisher of The Hindu, who produced this film, which was on reverse discrimination. It was anti-reservation and criticized judgments of the Supreme Court. Criticized in the film the various judgments upholding reservation. It may have been an unpopular thought, but it was a thought. The Madras High Court banned the film. The Supreme Court reversed it with the most famous judgment. It became so famous that even today it is being cited. It's called Jagjeevan Ram versus Rangarajan. As far as I know, copies were taken by Amnesty International, and it has even been referred to in a judgment of the House of Lords in England about how India has come further than most other countries in freedom of speech. And we are going back in point of time to the 1980s. We have Vishaka, the Vishaka case, where there was again what I said, justice springs into a vacuum. And therein came that theory that if there is something which is a basic right, a protection, something respected under the Constitution, and there is no law to take care of it, then the court, in discharge of its functions under the Constitution to uphold the Constitution, can make guidelines till a law comes in. And that was about harassment of women in working places. So at every stage, the courts have tried to interpret laws to keep in keeping with social movements. In the last 10, 15 years, there's been a tremendous change in social norms, social customs, in economy, in internationalism, in all these spheres. And so the laws have had to evolve. So we have a judgment in what's known as the privacy case, the Puttanna case, where you made a fundamental right, created a fundamental right, which the court said we have not created the right was implicit in Article 21. Environment has been brought under Article 21. Education has been brought under Article 21. Why? Courts cannot include a new fundamental right. The courts, however, can look at social needs and bring in rights. Same-sex relations has been protected, appreciating that this is today not an abnormality, but is a norm among persons who want to have same-sex relationships, and has respected it. I cannot forget how, in the privacy case, I had been briefed on the side of the Union of India to oppose privacy as a fundamental right. And I remember in a lighter vein, one of the judges turning to me and saying, Mr. Sundaram, are you opposing privacy being a fundamental right? And I said, yes, I am, because unfortunately, whatever my personal beliefs, the law is the law. But I remember then is when I had pointed out that the Constituent Assembly had specifically discussed and eschewed and rejected right to privacy being included as a fundamental right. And I said, look, this is the Constitution, upon which it was remarked to me that my opinions were very Scalian, Scalia being a judge of the Supreme Court of the United States at that time, or earlier. who believe that the Constitution being written in stone and accepted and went on the basis that the Constitution is an ever-changing organism which has to change with society, which has to change with times, which is why the courts have taken on to themselves so much more in the field of public interest. They have gone into areas of education, areas of welfare, areas of social injustices. Why? Which is the law which has dealt with this? We go back to the Constitution, constitutional morality, and justice will fill a vacuum when a vacuum is found. Justice will not allow an injustice to be perpetrated through a law. Now, this is where I am trying to explain to you that even today, original thinking is still such a must. You're at an age where you use technology to a great extent. You're also at an age where you're going to be threatened by AI or helped by AI. It's like a hammer which can either forge steel or break glass. So that you'll be discussing in that session. So the courts have been accused of having overstepped their limits, as having come into areas which does not concern them, which concerns the legislature, which concerns the executive. Of course, in India, we don't have the system of, in reality, our executive and legislature is one and the same because the ruling party is the executive. So it's actually between the two. And it's often said that the judiciary and the executive and the legislature have to go hand in hand. That is the biggest anomaly of separation on powers and balance of powers. What is separation of powers, which is the essence to a democracy? Is that each balances the other. That there should be a separation of powers so that church and king is not one and the same, to use the English expression, but each balance the other. How would this balance occur if both were hand in hand and went together? So a conflict between the judiciary and the executive is a must for balance of power, because that is the way one can be the watchdog of the other. And that is the role of the judiciary. That is why the judiciary is so important. That is why even today we consider it the one bulwark against any attack against democracy, against rights of individuals, of rights of society. Having said all that, what is your role as students today? As students of law today, you no longer have an obligation to your own purse. Of course, I'm not preaching to you. We're all became lawyers, we all are lawyers because we think it's a career which can be very materially beneficial. Of course, we enjoy the material benefit of it, and we should. But while we do it, don't forget that we are vital agents in this whole growth of law with a changing society. Law cannot grow unless the lawyer grows. If the lawyer does not grow, well, all these great concepts which we have of framing new laws, of shaping the future of law, we can forget about it. It happens because lawyers have to grow. And how do we grow? The integrity of a lawyer is vital. Don't forget that when we want that power of a lawyer today, why all of you become lawyers today is it's one of the most sought after professions. The power of a lawyer today vests in him a greater duty, a greater responsibility than the lawyers of yesteryear who became lawyers because they had no other job had. Today, you want the benefits of that power of being a top lawyer. With it comes the responsibility of discharging that power with the greatest good for society at large. The lawyer today is no longer a personal professional. He is today an integral cog in the societal wheel who has to play this role in society, because what he makes of himself is what he contributes, and that is where society itself will progress for the welfare of everybody who is to be assisted by that society. And that brings me to the legal education. You know, Bertrand Russell once said that the purpose of education should be that by the time every boy and girl leaves school, they should know how much they do not know and be filled with a lifelong desire to learn it. Legal education today cannot stop with teaching students law. They have to inculcate civic consciousness. They have to inculcate in lawyers concepts, beliefs, thoughts which are progressive, which will have two roles to play. One, maintain the status of lawyers and the judiciary in society. And how do you maintain that? By having that civic consciousness, by knowing that you have a role to play in formation of social norms, that you have a duty to give a dissent and disagree when you feel something is not just. Don't forget the dissent of today is the law of tomorrow. Don't forget that there was one dissenting voice, Justice H.R. Khanna, in the ADM Jabalpur. And today, his is the lauded voice. His is the voice everybody talks about as having, and ADM Jabalpur was overruled, and overruled with very strong comments. And Justice Khanna's view was upheld. That is what you should all know, is that you have a right to say no. I have a right to disagree. I have a right to question. But I have a duty to myself be filled with integrity, myself be filled with an abiding need to fulfill my role of civic consciousness. Don't forget, we are in a profession where stones can very easily be thrown against us so hard. Politicians may be corrupt, they may be found out. But 2 days ago, you all know about this unfortunate incident in Delhi, when a judge's house, a lot of money was found. And that is the talking point. And it should be, rightly so, but it is the talking point. If that money had been found in a politician's house, nobody would have said anything. But today, everybody, there is no other topic of conversation than that. Why? Why? Because the common man, every citizen has that abiding faith in us. And it's our duty to live up to the faith. And what do we get in return? What we get in return is the appreciation, our social status, our social standing, our income. We get so much. Let's not forget about our role, your role as students in the framing of the future of law. Because if you fail, there is no future to law. Thank you.